G'day everyone, welcome back to Frontlines and Faultlines with Mike Kelly. Really delighted to have you with me today because we have a very special treat. We have with me my very dear friend, Professor Tim McCormack. And we've covered quite a few subjects in these last few programs, and we've talked about issues to do with the laws of armed conflict and the concerning issues around lawfare and trying to shoehorn hot politics and making bad law into legal frameworks. But there's been a real need to try and understand how the mechanics of all that really works. And we've got no better person to talk to us about that because Tim is one of the foremost authorities in the world on the laws of armed conflict, but has been intimately involved in the structures that have been built around it in modern times in terms of international tribunal processes. He was involved with the tribunal for the former Yugoslavia war and the processes around that as an amicus curiae, and he was involved in the drafting of the Rome Statute for the International Criminal Court, and he's been involved since then with the ICC, and also has produced voluminous works, authoritative works on the laws of armed conflict, and was a chief editor for the very first sort of series of international humanitarian law works as well. But a prolific contributor to all of the discussion and scholarship around that. But more than that, and what I regard as more important, is Tim's been involved in the practical interpretation of that in the training of the members of our Australian Defence Force, which I think gives you the right and the fuller perspective on the law to make it practical for application. And he also worked with me on helping to design and deliver those courses and frameworks for the ADF. So long-time colleague, very respected one in the field internationally, and was a winner of the inaugural Golda Prize for his study on self-defence, the law of self-defence that we talked about a bit earlier in relation to Article 51 of the UN Charter. So I could go on forever on the introduction of Tim and his biography.
I'm not sure I can afford you to go any longer.
Yeah, we'd run out.
It's going to cost me a lot.
Yeah, so we will. We'll get straight to it.
Sure.
And Tim, great to have you here. And I know one of the reasons you're here is to conclude the 34 years of involvement with the Australian Red Cross.
Yeah, it's for me, it's been a fundamental part of my professional career to have been involved with Australian Red Cross and the International Committee of the Red Cross. And yes, I finish up this week on the National Advisory Committee on International Humanitarian Law, like you said, after 34 years. September, October 1991 was my first meeting. So it's been a long time.
Yeah, great contribution. And I think that's one of the things that's been so impressive about your life's work is the motivations, to make a difference, to make the world a better place. And so, it's been fun to work with you through that process.
You too.
And, we're in a fraught period of time now where there's a lot of pressure on the law itself and its continuing evolution and application. And as I mentioned, you've got a lot of hot politics out there that tries to use labels from international law of armed conflict as weapons in, their disputes. And so it's really important. And one of the things I'd like to do is kind of defend the integrity of the law so that it gets properly respected, that it will get applied and not just, dismissed as something, well, what's the point of this,
Yeah.
So the framework issues around this, I think, are really important too. And we've seen some of that play out recently. So I think it's important for people to understand what the International Court of Justice is and what the International Criminal Court is and the distinction between the two.
Yeah.
So with the ICJ, we've mentioned that it's part of the UN as an official organ of the UN. So can you explain what its jurisdictional reach is?
Yeah. I mean, for me, it's intriguing that the ICJ and the ICC sit about 5 kilometres apart,
right,
in The Hague. The Dutch have done a fantastic job of convincing the rest of the world that The Hague is the international legal capital. And, the ICC headquarters was agreed without, they were elected unopposed.
Right.
I can't believe that. Normally for a new international organisation, there's a big competition to host the organisation. Not unlike, Olympics or Summer Olympics or the World Cup. Maybe not quite the same amount of dollars, but, it's usually a contest. But
Right.
somehow or other, the Dutch managed to convince everybody ICC needs to be here. The ICJ is much older than the ICC. The ICJ was established in 1945 as the principal judicial organ, the UN Charter says, of the United Nations Organization. Unlike UN headquarters in New York or European headquarters in Geneva, the ICJ sits in The Hague, as did the predecessor court, the principal judicial organ of the League of Nations, established post-World War I, the so-called Permanent Court of International Justice.
Mm-hmm.
So both courts, they've never sat simultaneously. They, one followed the other. The ICJ followed the PCIJ, but they both sat in the Peace Palace in The Hague.
Right.
And the core jurisdiction of both of them is pretty similar. So the ICJ decides contentious cases between member states of the UN.
Mm-hmm.
And there are a number of ways that it can exercise that jurisdiction, but basically both states, two or more states, party to an international legal dispute, have to agree to or consent to the jurisdiction of the court.
Mm.
Number of ways that can happen.
Right.
Well, three basically. Some member states of the UN have made a declaration pursuant to the statute of the ICJ,
Right.
the multilateral treaty establishing it, part of the UN Charter, sort of an annex of the UN Charter.
Right.
When a country, we call them states, it's not state of origin, it's not blue on maroon. This is
Can be at times.
a sovereign nation state becomes a member of the UN. It is automatically a state party to the statute of the ICJ.
Right.
Under the statute, sovereign nation states can make a declaration, a voluntary declaration, accepting the compulsory jurisdiction of the court in respect of other sovereign nation states that have made the same commitment.
Okay.
So Australia's done that, and I think last time I checked, around 50 or 60, about, slightly less than 1/3 of the membership of the UN has made that declaration. A second way so if two of those countries that have made those declarations submit their case to the court, then the court has jurisdiction to hear it.
Right.
But there are two other ways that it can also happen. One is if both countries party to the dispute are also state parties to a multilateral treaty that includes a clause that says in the event of a dispute arising in relation to the interpretation or application of the treaty,
Right.
the ICJ has jurisdiction.
Right.
And
Genocide Convention is one of those.
Genocide Convention is one of them. Yeah, good example actually. One of the few. There's not heaps of treaties like that, but there are a few, and Genocide Convention is one.
Right.
The third way that it can happen is if two states parties have not accepted the compulsory jurisdiction of the court by declaration, but nevertheless agree between them that they will submit the dispute to the court because it's better to do that than to go to war.
Right.
So there are a lot of maritime boundary and territorial boundary delimitation cases that come to the court that way.
Right.
We call it, by special agreement.
Mm-hmm.
And the special agreement, which sets the parameters of the court's jurisdiction, contains the case that the two parties are asking the court to decide.
Right.
So there are three ways that the court can exercise what we call its contentious jurisdiction.
Right.
But it also has a second jurisdiction, which is called the advisory jurisdiction.
Uh-huh.
And that under that jurisdiction, it doesn't involve two sovereign nation states party to an international legal dispute. It involves an international organization, whether it's the UN Security Council, UN General Assembly, UN Human Rights Committee, the Economic or Social Council, or some other multilateral treaty body, World Health Organization, or the International Atomic Energy Agency.
Right.
They can go to the ICJ within their sphere of competence and ask the ICJ for an advisory opinion on a question of international law.
Right.
And, both of those, the advisory jurisdiction and the contentious jurisdiction, are in play right now.
Right. And so with the advisory opinions, because you don't have the opportunity to have, as a contentious process, evidence presented by two parties to a potential dispute and a proper, process of evaluation and testing evidence. Those decisions or those opinions of the court are not legally binding, are they?
No, and not they can't be. It doesn't mean they're not influential, and often, contain some, interesting jurisprudence that we would, as scholars and practitioners, interpret and apply in relevant contexts. But that's correct, and it's also true though that in the contentious jurisdiction of the court, where both parties don't want to be there.
Right.
So obviously, if the case comes by way of special agreement between the parties, then the chances are that both parties are going to participate.
Right.
Court's going to hear both views, and the court's going to make a decision on the basis of the material that's presented. And it's much more likely, I'd say 90% likely, that because both, maybe it's even higher than 90%, but maybe something short of 100, both states have agreed to submit the case to the court.
Right.
The one that loses is going to accept the decision because that's part of the sort of calculus, if you like, about why we're going to the court in the first place. But the contentious jurisdiction work also arises in circumstances where one of the parties doesn't want to be there.
Right.
And that can happen where two states previously have made a declaration accepting compulsory jurisdiction. One initiates the proceeding. They want to be there.
Right.
The other one doesn't want to be there and sometimes doesn't turn up. Okay. And US and Nicaragua is a good example of that.
Right.
So you have the court awarding the case, making the judgment, awarding a judgment against the side that loses, and they might still not accept it. So technically it's binding, but the court doesn't have any enforcement power.
Right.
Actually relies on the UN Security Council to enforce its decisions. And if the state that's just lost is a permanent member, that's going nowhere.
Yeah. And look, with the advisory opinions too, would it be accurate then to say that the real force of any of its opinions depends in terms of establishing a norm, I guess, of international law, depends on the international uptake of that opinion, and in particular, whether they actually apply it in their practice, not just say, yeah, that's okay, but then go away and do something else. But would that be accurate to say in terms of the weight that it carries on?
Yeah, I think that's exactly right. If a majority of UN member states accept the advisory opinion and act on it, then it's going to be taken much more seriously than an advisory opinion that gtake up. And that, of course, I think depends on the subject matter a bit. But, right now there's a very, potentially very significant advisory opinion process underway. The court hasn't given the opinion, but they've had submissions from a record number of participating states in the international legal responsibilities of states in respect of climate change.
Right.
My understanding is that it's a record number of states that have actually asked to appear and made submissions. And, it'd be interesting to see whether when that opinion's handed down, what it contains, and what states in the international community do about it.
Right. And it's really interesting to watch that dynamic in play, because one matter that I referred to earlier was where there was an advisory opinion on the law of self-defense, which basically attempted to assert that under Article 51, if you were attacked by a non-state actor, that the self-defense provision there, the inherent right of self-defense, wasn't actually triggered, that it only related to like an international state-on-state situation. And it seemed, from my looking at the subsequent approaches to that was almost universally ignored in practical application.
Yeah, no, it's a good example, actually. It was the advisory opinion on the route of the Israeli wall, wasn't it? The separation barrier between Israel proper and the West Bank, particularly through East Jerusalem, Western East Jerusalem. But yeah, it wasn't many years after that 9/11 happened, and no one. I mean, the UN Security Council accepted resolutions endorsing the US's right of self-defense in response to an attack by a non-state armed group on the Twin Towers of the World Trade Center. So, and no one, actually, very, very few states. I know of no states that disagreed with that. In fact, I think plenty of them would say, if we're subject to an attack that is of the scale and gravity of an armed attack by the forces of a foreign government, we're not waiting around for the Security Council to defend ourselves if we have the capability of doing that.
No, and I think that's what the reference to the inherent right of self-defense and just delineating an armed attack, but not, specifying that it had to be a state. I think that was really echoing, and we talked about this a little bit, the Caroline case, which was, in fact, a situation where the US couldn't control its citizens in cross-border incursions into Canada. And the British, did their own solution to that. And
took the law into their own hands.
Yeah, eventually, right? Yeah. So, and then the correspondence, it really established that, where you had no right to expect that, the grievance could be resolved, but because the people in control weren't able or willing to do something about it, then, you're entitled to respond. That seemed to be then accepted by the US, and we've been on that road ever since.
Yeah, no, I always understood the term inherent in Article 2, Paragraph 4 of the UN Charter to mean a right that pre-existed the Charter. And that means in customary international law, in the Caroline case of 1842, is critical aspect of the development of that customary law. I don't think it was the only thing that predated the Charter. But, I when I did my own PhD, I really enjoyed getting back into the verbatim minutes of the equivalent of Hansard, I guess, the transcript of the debates in San Francisco, the drafting of the Charter. And Article 2.4 was never intended as a absolute prohibition on the use of force, because we all understand that that states have the right of self-defense. I mean, we can't write that out of the UN Charter. So yeah.
And we did talk about this travaux préparatoire thing, preparatory work, as being a really critical part in international law, and often neglected by pseudo-authoritative commentators who don't do that deep work, that deep dive.
Yeah, I mean, for me, I guess I had the privilege of working on a PhD topic for 4 years of my life, so I was into it like one thing. It was back in the day before those preparatory works from that era were digitized.
Right.
So I remember sitting in the library of the Peace Palace in The Hague, the ICJ, because they had them all in hard copy.
Right.
And I was, poring over the record of the diplomatic conference in San Francisco. And, I wouldn't say I was being paid a fortune to do it. The scholarship was meager, but I was actually being paid to do that. It's an enormous privilege.
Yeah, well, that sort of underlines, though, the sort of scholarship, the effort that you need to invest to be authoritative on this. And, so if you get a group of solicitors that pull together and prognosticate about this sort of stuff, and their conveyances and, real estate agents, etc., or whatever, then it's not really authoritative on these issues.
No, I guess, I find the whole concept of expertise, really interesting one in the era of social media, because I've grown up, I'm an old fart now, but I've grown up with a tradition that values subject matter expertise that is hard won by a lot of effort.
Yeah.
And a lot of effort in primary sources. Yeah. And, when you have this sort of era where my opinion's as valid as yours is, don't tell me I don't know what I'm talking about. It's sort of counterintuitive to what the academy and the university is all about. Yeah. So it's a strange era to be in.
I've said it's kind of like having a podiatrist do brain surgery. You wouldn't ask them to do that. So it's a good point underlined. Thanks for your personal experience on that front.
No, look, I'm happy
4 years of your life.
I'm happy for my kids to keep me grounded. I'm not happy for them to tell me I don't know what I'm talking about on the subject matter of Article 2.4, Article 51, for example.
I don't know anybody in the world who is more of an authority on that. So that's important. But so to step back a little bit, like how do they actually then select the judges for the ICJ? How does that process work?
There are 15 judges that are elected for a 9-year term. but not all at the same time. It's a little bit like a half Senate election, except it's 1/3 at a time. So every 3 years, 5 new judges are elected.
Right.
Under the statute and the rule, not the rules, the procedures about that are laid out in the statute of the ICJ. So it is possible to do 2 terms. Like one individual can be re-elected for
not prohibited.
18 years is allowed.
Right.
You can't have more than one judge from any one member state of the UN.
Okay.
And there is a sort of, I don't know that it's actually written down, but a sort of unspoken convention about the allocation of seats, those 15 judicial positions distributed between the different geographic groupings that make up the membership of the UN.
Right.
So by that, I mean, you and I know what I mean, but some of the audience won't. We have Asia, which is everything from, the subcontinent, well, actually the stands, all the way through to the Pacific.
Right.
It's the biggest geographic grouping. Africa, Latin America, Eastern Europe, and then this catch-all, WEOG, Western Europe and others group, into which, in addition to Western Europe, the US, Canada, Australia, and New Zealand fall.
Right.
So each of those groupings, well, member states are entitled to nominate a candidate for election to judicial office, and the elections are held at UN headquarters in New York on the every 3 years, and depending on the distribution amongst the 5 geographic groupings, or when 5 are elected, because it's not always one each.
Right.
It might sound like it should be, but the fact is that that the UN permanent members of the Security Council pretty much have a permanent judge. Doesn't always work out. UK lost the position because, a combination of reasons, but Sir Christopher Greenwood was not elected to that position. So it doesn't always sort of work out exactly as you'd imagine, but Australia is interesting. We're not big enough to sort of demand one of the 15 positions all the time. We've only had judges on there from time to time. We currently have Professor Hilary Charlesworth. She took over the position vacated, the judicial position vacated by Professor James Crawford, who died prematurely before the end of the 9-year term. He was in his 3rd 3-year cycle, but I think like 7.5 years in, Hilary was elected and served out the rest of his term, the remaining 2.5 years, and then ran for re-election and was successfully re-elected to a 9-year term. So, but they were the 2nd and 3rd Australian judges. The first Australian judge was Sir Percy Spender in the 1950s, who was president of the court for 3 years, and
a relative of Allegra Spender, the member for Queensland.
Yes, she is. She's a descendant of he is. Yes, yeah. So we haven't had heaps of judges in the 70 year history. It's 1945, or is it 80 years now? Yeah. I don't know. How's my maths? Shit house.
A long time.
80 years. 80 years this year. Far out. We've only had 3 judges. Yeah. That election process is quite an interesting experience.
Right.
I've observed it a couple of times when I was with Australian government delegations at UN proceedings in New York around about the time of the election, just coming up to it. And, I got lobbied by candidates. I thought, no, you don't understand. I'm only here as an academic, and you got to go and talk to the head of the Australian delegation. But it's pretty intense. Like there's a lot of trading of votes. Like you vote for our candidate in this election, and we'll vote for you in whatever you're running for.
Right.
So Australia, like I was saying, we're not big enough to, or influential enough to have a candidate in every electoral process. We've got to pick and choose which ones we want to nominate for, and what are we going to trade off to be able to do that.
And effectively, the governments nominate these judges.
Yeah. I mean, they do.
Right.
They do.
I guess, and one of the things we've talked about in earlier episodes is this dynamic that's been underway, particularly in the last 10 years, where we've gone from, and this is the VDEM Institute, University of Gothenburg, Sweden, in the last report sort of surfaced that we've gone from 48% of the world's population 10 years ago living under autocracies to now 71% of the world's population living under autocracies.
That include the United States?
Well, let's see the next report, because
Yeah.
I reckon and they have different categories of democracy, so liberal democracy, etc. So, yeah, they may sort of, depending on this trend, whether or not they slide from liberal democracy category, but 71% in autocracies, the rest in democracies, but only 13% in liberal democracies. So, what's interesting about that to me is the effect that's having on these UN institutions. So where you've got, it's going to be an autocracy that nominates a judge, from some of these geographic regions.
Yeah.
So I guess there's going to be some vulnerability there to what sort of judge you get and whether they truly have the expertise to be on the International Court of Justice.
Yeah. I mean, I guess I've been more interested in election to judicial office in the last, say, 20 years than previously, because I've been following especially the ICC judicial election process.
Mm-hmm.
And I think for my concerns about some of the candidates has been less about, which country nominated them, and more about competence.
Expertise. Yeah.
And, I mean, I don't think we can... You're right to raise it, because I think it is a concern, and the part of the problem is that we can say as much as we like to the states that are that are kind of thinking about, the sovereign nation states that are thinking about nominating their nationals. For God's sake, please nominate someone who's competent, an expert in international law for the ICJ or in the ICC, either with extensive criminal judicial experience, judging complex criminal trials, or, with the academic expertise in relation to the subject matter, law of armed conflict and international human rights law. There's a vetting process that the Assembly of States Parties of the ICC has set up. I'm not sure that there's anything similar for the ICJ, but they've established this process where this group, trusted amongst the Assembly of States Parties with fairly broad geographic distribution, gives recommendations about whether this person's competent or isn't. Now, they went through that process in the last election, and one of the first judges elected, was in their not competent list.
Right.
What is that? I mean, I'm not going to name names about who it is, but it's pretty obvious that that person doesn't speak either English or French, the working languages of the court, and therefore, what not only linguistic challenges, I think, doesn't really understand the law. What sort of contribution are they going to make to the proceedings of the court? It frustrates me like one thing.
I can imagine, particularly when you're sitting here with your expertise and, should have been a member of either of these courts, but it is a worry, because I thought the last president of the ICJ, he didn't have a very long term because he went back into politics in Lebanon, but it seemed to be a really fraught selection, that, in my view, on the court, from the point of view of that depth of knowledge of the subject matter.
Yeah, I mean, in contrast, his predecessor was...
Joan Donoghue,
incredibly impressive, and her replacement also, actually, Sarah, what's her name, from Cleveland, from Columbia Law School in New York. So, I would say that not every judge is going to reflect the politics of their sending state. So
I think Julia Sabatinda is a good example of that.
Yes. Yeah, she probably is, actually. But I mean, I wouldn't say that wouldn't be my only concern, the one that you've raised, isn't it? Because the fact that certain states are nominating candidates who are successfully navigating the electoral process doesn't necessarily mean those candidates are going to, toe the sort of party line in terms of the politics of the sending state. But for me, the competence question is threshold.
Key one.
If you don't have that, we shouldn't be appointing them.
Yeah.
They shouldn't even be nominated, but they certainly shouldn't be elected.
Right. So you're seeing that play out. So that same sort of dynamic really does affect the ICC, even though it's independent of the UN structures. It's meant to be a standalone independent court
Yeah.
that can't be interfered with, but it's still got that vulnerability to it in terms of that.
It has. Yeah. And I'm sure it's multifactorial as to how it happens, but for me, it's very frustrating to watch the electoral process and see some people who are, being elected. In the ICC's case, it's 18 judges, not 15.
Right.
There are 6 elected every 3 years, also for a 9-year term. So the sort of process is similar, but you're right. It happens under the auspices of the multilateral treaty, the Rome Statute, that establishes the court, not the UN. The elections, so the annual assembly of states parties to the treaty establishing the ICC meet every year.
Right.
In The Hague, 2 years, and then in the 3rd year when the election happens in New York, because the General Assembly, meeting hall is really set up for large delegations from all over the world. Right. And it's much easier to conduct the electoral process there. Right. The Hague doesn't have anything quite equivalent to that.
Right.
So the elections for the ICC judges happen coincidentally in the same venue as the elections for the ICJ, but not at the same time.
Right. Well, it's a fantastic background on those aspects of the structure and whatnot. And what we'll do in the next episode is we'll talk about the issues associated with what the process is of the ICJ, because of the confusion that's been apparent in some of interpretation of, what each step of the process is all about.
Yeah.
And then looking at the ICC in terms of particularly some of the fraught bits around the complementarity and whatnot, and your role in the drafting. So we'll wrap it up there for this week, but really thanks for being with me. I'm really grateful for Tim to unwrapping that for us in a digestible way. Didn't get too much Latin in there, which is great. So we'll see you again next week when we'll talk to Tim about those elements of the ICC and ICJ that are front of mind at the moment.